Assalamu alaikum wa rahmatullahi wa barakatuhu. Welcome to a seminar on Islamic wills and estate planning with Will Solicitors, Rizwan Rashid, and in association with Simply Ethical. For those who don't know me, my name is 𝗥𝗀𝘵𝗄𝗵𝗶𝗱. I'm the CEO of Simply Ethical, and it's my great pleasure to have this seminar today for all of you to hopefully, inshallah, benefit from. I just want to say a few words about this topic. Islamic wills, as you know, is something that I think will touch all of us at some point. There is a very famous narration, which I'm sure Rizwan will go through, but there's a very famous narration from the Prophet, peace be upon him, where he said, do not let 3 nights pass without having a wasiyyah, if you've got anything to bequeath on your death. And the reason and the wisdoms behind that, again, as I said, Rizwan will go on. But for those of you who've had the loss of family members or seen close friends pass away, and the aftermath of when someone passes away, it's undoubtedly great to have clarity on what that deceased person wanted to do with their wealth. Otherwise, there is a big chance of confusion, and unfortunately, it can result in problems and disputes and the like. So that's why our great religion, where these teachings are so they seem so dramatic or so important, but that's it's to save us from these harms later on. So without further ado, I'm going to pass over to Rizwan. Rizwan is someone I've known for over 10 years. Him and Harun Rashid are the 2 main people at Will Solicitors. I would say that they're the foremost practice, if you like, when it comes to Islamic wills in the country. They've been thought leaders, they've been pioneers in the field. I mean, very small story is that I met Harun good sort of 15 years ago when I read an article he had written in ML magazine encouraging people to get their will done. And actually that was the start of my entrance and time in Islamic finance, because that was the first step I took, really. And he actually introduced me to the people I started working with in Islamic finance after that. So myself and Harun go back a long way, and we have a very close relationship with Will Solicitors. And I'm sure you're going to benefit hugely from tonight's presentation. So Rizwan, please, the floor is yours. Thank you.
Bismillah. Jazakallah khair. Faisal, thank you for the introduction. It's a little bit even more urgent than what you mentioned about the 3 nights. The hadith is actually for 2 nights. So
wow.
It's one of those things which is often overlooked within Islam with Muslims. But it's something that over the last few years we've had a lot of experience with over the last decade or 2. And we're seeing a lot more Muslims taking this area seriously, particularly because family members are passing away and they're having to deal with it themselves. When it's a bit more abstract, you tend to leave it to the side. But inshallah, we'll cover all of that today. I thought I'd just begin, inshallah, with a little introduction in terms of Will Solicitors and ourselves. So we specialize in tax-efficient Islamic wills. We've been doing this now for over 15 years or thereabouts. That's what we specialize in, and that's our kind of area of expertise. Related to that also is probate, which is the administration of estates. And also, when you're looking at dealing with someone's estate, you have to look at whether they are in need of potential lifetime trusts or will trusts for IHT planning. So a lot of individuals have estates which fall over above certain thresholds, which mean that inheritance tax, IHT, potentially becomes an issue. So these are the services we provide. We're a regulated solicitors firm, STEP qualified, which STEP is the Society of Trust and Estate Practitioners, and it's a specialist organization for particularly solicitors who work in this area, in this field. So within our firm, we have STEP qualified members, and that's kind of the quality mark for will and estate planning people. From the Islamic side, we've taken a great deal of care and advice and training to make sure that our solutions that we provide are not just relevant for under English law and the tax system, but also from an Islamic perspective, making sure that all of our advice is tailored to a Muslim clientele, and that everything is as far as possible done in accordance with the Sharia. So like I said, we've got over a decade's experience doing this, and this is where we really work on. We don't try to do more than our expertise, and we want to concentrate on this particular field. So the idea of today is basically to split the presentation up into two parts. The first is giving an overview of what happens when someone passes away, and what we have to deal with. And then we can also look at the Islamic will and how that is incorporated and how that is dealt with within the English law system. So in terms of the estate administration, when someone passes away, we're either dealing with what's known as a will scenario or an intestacy scenario. So will scenario is obviously when someone has a will in place, and intestacy is when they've not prepared a will, or they've had a will previously and they've destroyed it, or it's been lost, and we don't know what was done with that will. When you have a will, the things that you have to look out for in terms of the will itself are the Sharia compliance, the tax efficiency of the will, cover things like such as guardians and executors and trustees, asset protection. So a lot of estates, they have young children and other individuals who would inherit, and we have to make sure that we have a structure in place which protects the assets for them and it's not unnecessarily wasted away. Additionally, our wills will cover things such as funeral wishes, nasiha in terms of advice to the family left behind, and charity. So going through this presentation, I hope to touch on many of these points, and then at the end I think there'll be an opportunity for questions from those who are watching live, and I should be able to cover some of those questions if you have some. So in terms of the intestacy rules, when we're dealing with an estate where there's no will, then under English law, the first people to inherit are the spouse and children. Current rules are that the spouse inherits the first £270,000 of assets, plus any personal items. So personal effects, jewellery, etc. Those will go all to the spouse, along with the first £270,000. If the estate is above that value, then the remainder will be split 50% to the spouse and 50% to children. The point to remember, especially for Muslim clients, is that where there's only a nikah and there's not a registry marriage in this country, then the spouse won't be treated as the Islamic spouse won't be treated as the legal spouse for that purposes, unless they had their nikah abroad in a jurisdiction which recognized the nikah. So, for example, a lot of clients, South Asian or Southeast Asian nikah in Pakistan, India, Bangladesh, and then when they pass away here, then they're legally recognized as spouse. Whereas if the nikah is done in this country and it's not registered, then there is no recognition of that. If there's other family members, then it's only the spouse and children who will inherit. So the entire estate will go to the spouse or the children if it's them alongside other family members. So if it's a spouse plus parents, spouse will get everything. If it's a son or daughter or children with other family members, the children will get everything. It's only if there's not spouse or children that other parents, siblings, grandparents begin to get a look in terms of the estate and the receiving something from it. In terms of the administration of the estate, the people who have the right to administer the estate, i.e. the people who can go to the court, deal with all the assets and legally deal with matters, are the executors of the will. So if a person has a will, they get to choose exactly who's going to deal with their estate, and that will be written down within the will itself. Usually we recommend 3 or 4 executors and trustees, and their job is to administer the estate, which I'll come on to further down. If there's no will, as in the intestacy scenario, then it's only then it's the administrators rather than the executors, and the administrators is basically in terms of the beneficiaries of the estate. So it usually be spouse, then children, then parents after that. So in that scenario, the deceased doesn't get to choose who their administrators are. It will all be dictated by law. The liabilities of the estate must be deducted from the assets in order to work out if there's any inheritance tax liability, and we'll come on to inheritance tax shortly as well, inshallah. Some of the things that need to be considered here are funeral expenses, debts owed to others, although it's important to be able to evidence these debts, because if any debts are put down on the paperwork, then HMRC is going to want to see evidence of this, because it obviously reduces the size of the estate and reduces the inheritance tax bill. So they want to make sure that their actual debts are not just made up, or even if they're not made up, they have to have some evidence of those debts. Obviously, any outstanding bills at the date of death can also be deducted. Then there's expenses post-death, and these are called administration expenses. These aren't deductible for the value of the estate, but they include things such as court and legal fees and any post-death bills that may have come, either income tax bills or other bills which weren't due as at the date of death. So whatever's due as a result of the death or at the date of death, then that is deductible. Anything post is not deductible. Few other points when administering an estate which are important to consider are claims against the estate. So what will sometimes happen is that disgruntled beneficiary family member will want to make a claim against the estate to say, hold on, everything's been given to X, I deserve, or I'm entitled to a share in this estate because my father, my mother was financially looking after me, or my husband, my wife, whoever it may be. Such claims have to be made within 6 months of the date of the grant of probate, or the grant of letters of administration, as is called in intestacy. And that point is important because if they don't claim within that period, then it's very unlikely that they'll be allowed to claim after that, unless there's some extenuating circumstances, the person was ill for a period of time, whatever it may be, but that will require court application. So any claims that are made should be made within 6 months of the date of the grant. When we get contentious matters, and this is increasingly something that we're seeing over the last couple of years, especially where there's contention between family members and beneficiaries, it's important to take action in terms of making sure that steps aren't taken without the knowledge of the individual who's dealing with things. So we can enter things such as caveats, which stop a grant being taken. And then there's a process there which has to be followed. If it does get contentious, it can go all the way to court. It can be quite costly in that sense, because it can take months, years to deal with those types of estates. When we're dealing with an estate, we also have to look to see if there's any debts outstanding. And there's something called a Section 27 notice, which will allow you to find out if there's any outstanding claims, or advertise those claims. Now, that advert is made in the London Gazette and the local newspaper. So 9 times out of 10, most people won't see that. But if they do then make a claim, then it's not against the executors or the administrators of the estate, it's against the beneficiaries themselves. Once the beneficiaries have received their money, then those who are claiming the debt can go directly after the beneficiaries rather than the administrators, which is important, because if the administrator or the executor isn't receiving anything in the estate, they don't want to be liable for the debts of the estate. Similarly, if beneficiaries are receiving something, then certain checks need to be made in terms of bankruptcy to make sure that the money doesn't go to them if they're bankrupt, because again, the administrators would be personally liable for that, or potentially could be. I mean, inheritance tax is an important point, and it's increasingly an area where Muslim clients are having to consider what to do, particularly in London area, where a single house will pretty much always put you into the inheritance tax bracket, and even elsewhere. And even with those who have medium-sized estates, if you like. Inheritance tax payable within 6 months of the date of death, otherwise interest starts to become payable. And you can make payments over a certain period of time, over a 10-year period, if you have property which you want to pay or you have to pay inheritance tax on. Again, going back to that point about debts, these must be evidenced by some sort of written documentation or transfers or other evidence to show how much debt is owed, etc. And outstanding debts and bills can be reduced from the inheritance tax bill. Moving on to the more interesting part of this discussion for most of you would be the Islamic will itself. Going back to that hadith of Faisal mentioned earlier, the Prophet ﷺ said, "It's the duty of every Muslim who has anything to bequeath not to let 2 nights pass without writing a will about it." So it's a hadith in Bukhari, and the narrator of that hadith actually said that when he heard the hadith, he didn't let a single night pass before writing his own will. Now, the bequest within Islam, as I'll come on to, doesn't relate to the entire estate, because a certain portion of it is actually fixed, and a certain portion, which we'll come on to, is allowable to give away to those who don't automatically inherit. So in terms of the Islamic inheritance rules, there's certain rules, and the first is that there's no hierarchy in terms of those who are eligible in Islam. So if you're eligible as a beneficiary of the estate, you're eligible as much as any of the other inheritors to your fixed share. So it's not like in English law where we saw that the spouse comes first, then the children, and then everyone else. Islamically, if you're an inheritor, then you will be having a right just as much as the spouse or the children. The second kind of rule to realize is that it's always the closest inheritors who inherit. So the closest inheritors to any individual are the spouse, the children, and the parents, because there's no one in between you and your parents, you and your children, you and your spouse. So they always inherit a fixed share in the estate, provided they're Muslim. And it's only if certain of those beneficiaries are not around. For example, if there's no son, grandson, or father, grandfather, then the next level of inheritance potentially can benefit, which is brothers, sisters, and thereafter others. So I mentioned earlier about the hadith of Prophet ﷺ, where it was mentioned about not letting 2 nights pass without writing a will. In that jurisdiction, at that time, what was being referred to was the 1/3. So there's a 1/3, up to 1/3, where the individual has a wasiyyah, a choice on what to do. And that is basically something which allows him to give away that 1/3 to anyone who doesn't automatically inherit. The other 2/3, at least 2/3, so it could be more than 2/3, it could be 90%, and 10% is what the individual has chosen to give away freely. The other 2/3, at least, are fixed, and it will go back to who is alive at the time of the deceased passing as to who gets that 2/3. The 1/3 choice can't be used to benefit the beneficiaries of the 2/3. So as an example, if you have 2 children and parents and a spouse, what you can't do is say, I'm going to give 1/3 to my spouse, and then the other 2/3 will be split Islamically as well. That can only be done if the other beneficiaries agree to it. You can make a wish about that, but by right, Islamically, the fixed share inheritors are the ones who inherit, and they can't receive from the 1/3 unless the other beneficiaries agree to it. Because the principle there is that you can't unfairly benefit one of the beneficiaries over the other. The rules of the inheritance are quite complicated, but it's been studied, and it's something that I looked into myself and writing a book about, in terms of the justice of these rules and how Allah has made sure that everyone has their right and their due right, and that goes with that right and responsibility. Now, even non-Muslims have looked into this, and this senior civil servant in the British Raj, at the time, the British were looking at the laws of the natives, as they would say, and they were looking at the laws of the Muslims and how they dealt with things, and the Hindus and how they dealt with things. This particular senior civil servant was concentrating on Islamic laws, and not being someone who's versed in these things and looking into it, his conclusion from all of that was that these rules that are in place within Islam gives all the right benefits to those who are entitled, such that it's difficult to conceive of any system which is more strictly just and equitable. These are things that we as Muslims believe, and it's something that we understand intuitively, but Allah has set this out, and for those who study it, they can also understand how it works and why it works in the way it does. And that's something that is certainly worth understanding in more detail if you're interested, because it just shows the beauty of Islam, it shows the beauty of the Sharia, and how Allah has managed, how Allah is able to give the right share to the right individuals at the right time. In terms of the shares that are due, a few points to note. The first being that ownership is up to the deathbed. So when an individual owns his assets, he owns his property, he owns his bank accounts, etc., it's important to note that he only owns them up until the deathbed. So in his final illness, when he or she is passing away, that ownership ceases to be theirs anymore. So what they can't do Islamically is give away all their assets when they know they're about to pass away, and then they subsequently do, because that is a way of disinheriting the rightful owners of their inheritance. If a person is healthy and they decide to give away all their assets, and then the next day they get knocked over by a bus, for example, that's not a problem from the Islamic inheritance point of view, because they're not anticipating that they're going to pass away. And it's one of those things that people can give gifts during their lifetime, but when they are in that space where they're on their deathbed, then that right ceases from an Islamic perspective. Again, it's always the closest inherited relatives who inherit. And the verses of Surah An-Nisa, ayahs number 11 and 12, ayah number 176, explain pretty much the majority of the rules, alongside a handful of hadith that also mention who should get what and how the distribution is to be worked. The other point to mention from the verses of Surah An-Nisa, and Surah An-Nisa is the kind of key surah which mentions about inheritance, about the shares of inheritance, about how you should deal with inheritance, how you should deal with guardianship, executors and trustees, etc. And one of the points mentioned within those first 14 ayat and the last ayat is about charity. So it's emphasized in those verses that when it comes to the time of division, those who've received something should make sure that there's provision for those who are relatives who are needy, the poor, orphans, etc. So this is a key injunction within Islam to make sure that you have something in place, and you need a will in place in order to give to charity, because if you don't have a will in place, then no charity is going to be given unless your beneficiaries decided to do it on your behalf. A couple of examples, one example which will help to illustrate a few of these points. So going back to tax efficiency, if you look at the estate of an individual, they have up to £325,000, which is eligible tax, which is essentially tax-free. There's an additional £175,000 which they can also have, which is also tax-free, and I'll come on to that. That comes with certain restrictions. Being a married couple, they have 650, so up to £650,000 is potentially tax-free, and the additional amount of £350,000 is known as the residence nil rate band, and that applies to individuals who have a home and who give that home to their children, and it has to be a direct gift to the children in order to achieve that additional allowance. So in total, a married couple can have up to £1 million potentially tax-free. From a tax efficiency perspective, if we look at the Islamic aspects, it becomes a bit more difficult. The reason for this is, from a normal English law perspective, a normal non-Muslim couple, they would tend to give everything to the surviving spouse and thereafter to the children. This is tax efficient because anything that passes between husband and wife or wife and husband is completely exempt for tax purposes. So the individual could have £10 million estate. If they give it to their spouse on first death, there's no inheritance tax to pay. The problem we face when we're dealing with this from a Muslim angle, in terms of someone who wants an Islamic will, is that the surviving spouse only has up to a maximum of a half of the estate. And that's a case where a wife passes away leaving a husband but doesn't have any children of her own. Her husband gets half of the estate. If the wife has children, then the husband only gets a quarter of the estate. And on the other side, if husband passes away, he doesn't have any children and he leaves his wife, she will only get a quarter. However, if he does have children, she will only get 1/8. So the problem you maybe realize now is the spouse's share is much more limited Islamically. And the reason for that is because other inheritors are deemed to be also worthy of inheritance, i.e. children, parents. But that poses an issue for us for tax purposes, because how do we get around this? We want to make sure that we deal with things Islamically correctly, but we don't want to pay inheritance tax unnecessarily. So a simple Islamic will is a lot less tax efficient than it needs to be. And the solution to get around this is to use trusts within the will itself. We use a variety of different trusts and a combination of trusts to make sure that the will of the individual is as tax efficient as possible, depending on what assets they have, if they've got business assets, the size of the estate, etc. So if we have a look at a typical example of this, let's take Zaid. He's married to Amina, and his parents, Khadija and Bakr, are alive. And he has 3 children, 1 son, Amr, and 2 daughters, Iman and Sophia. Now, if Zaid were to pass away today, then Amina, his wife, would get 1/8. And the reason she gets 1/8 is Zaid has children. It doesn't have to be with Amina, it can be just Zaid's children. But as long as Zaid has any children alive at that time, then Amina will only get 1/8 of the estate. The father and the mother both get 1/6 of the estate. And the balance of the estate passes to the 3 children and is split up into 4 parts, with Amr, the son, getting twice share of the daughters, of each daughter. So if we look at the tax bill, if Zaid has a £1.2 million estate, including £250,000 of business assets, his wife, Amina, is entitled to £150,000. His mother and father each get £200,000, and the remainder goes to his son, who gets £325,000, and his daughters, who get £162,500 each. The total estate is £1.2 million. We can take off that nil rate band that I mentioned, the £325,000 allowance. We can also take off the amount that's passing to his wife, which is £125,000. And the business assets are entitled, in this scenario, they're entitled because he's got a trading business. He's entitled to relief on that business of up to the value of the business, 100% of the value of the business. So we can take off a further £250,000. So the total taxable estate, after doing all of that deductions, all of those deductions, is £500,000. And inheritance tax is charged at a rate of 40% on that amount. In this example, I've ignored the possibility of getting the residence nil rate band, which could potentially give a little bit more of a exemption, because it's not always available and it has quite a few conditions to that. So in this scenario, with Zayd having a simple Islamic will, his inheritance tax bill on first death is quite sizable, £200,000 on a £1.2 million estate. So 1/6 of the estate is going to the taxman, and everyone apart from the son is getting less than the taxman. Yeah. So that's how, in that scenario, the taxman is the second most, the second in line in terms of beneficiaries. Now, if we do this in a tax efficient manner, we still get all the benefits of doing things Islamically correctly, but we can, inshallah, make sure that tax isn't paid unnecessarily. So rather than Zayd giving his assets directly to his beneficiaries in the Islamic proportions, what we can do is instead pass all of his estate within a trust fund. The trust fund, if the income of that trust fund is the entitlement of his wife, then the entire asset is tax-free, because for tax purposes, it's deemed as part of the wife's estate. So the tax bill on first death is now 0 instead of £200,000. And that's simply by having a tax-efficient Islamic will in place with the right provisions to make sure that the wife is, for tax purposes, the inheritor of the wealth. Now, for Islamic purposes, what we do is we have a letter of wishes in place. And the letter of wishes confirms that, yes, although some of the income of the trust fund, whilst assets are within the trust fund, is due to Amina, the capital should be divided in such a manner as to make sure that everyone gets their correct proportion of the inheritance. So Amina's share would be 1/8. She would receive some from income if there's any income, and she would receive the remainder from the capital. And then all of the other beneficiaries will also receive from the capital. And the letter of wishes is also a way of making sure that the individual's wishes are properly taken into account in terms of how he wants to distribute things and what his particular requests are for the family. So on second death, between first and second death, on second death, we will take Amina's estate, we will add the value of the trust fund if there's still any assets within the trust fund. And there will be 2 nil rate bands applicable, because by passing everything into the will trust, Zayd didn't use up any of his allowance. So here on Amina's death, there'll be up to £650,000 potentially tax-free. Additionally, if the residence nil rate band is available, then Amina will have up to £1 million, which is tax-free. And if that still isn't enough, then we can look to do more tax planning between first and second death. So after Zayd's passed away, we can also look to potentially create trust funds or gifting strategies with Amina to discuss those options with her to help to reduce any potential inheritance tax bill on second death. You can see there's quite a lot there. I haven't gone into all the aspects of potentially why you'd want a will, in terms of guardianship, in terms of executors and trustees, in terms of making provision for charities. And there's a lot more to it in terms of pensions and other life policies, etc. But there's limited time, and there's plenty there in terms of things that I'm sure people will have questions about. So I think, Faisal, I'm happy to move over to questions if there are any questions.
No, thank you, Rizwan. So as Rizwan says, there's a lot to take on board there. This is a very clever solution, by the way, because as you probably notice, the trust fund, the whole basis upon which that tax planning is happening is the fact that that trust fund, where the wife is getting an income from that trust, it is deemed as if she's getting the assets, or that all the assets are being passed to her for tax purposes. And therefore, the spouse exemption you get for anything that goes to the spouse, and there's no inheritance tax. But like Rizwan says, you have this letter of wishes, which then basically allows the Islamic distribution to take place. So it's a very carefully crafted solution, which I think many Muslims are benefiting from, because otherwise, as Rizwan pointed out in that example, £200,000 of inheritance tax would be payable on the first death. So it's a very good solution, and it can save a lot of inheritance tax whilst being faithful to the Islamic distribution. So as Rizwan says, also there's plenty of questions because every scenario is potentially different. There are lots of different other assets. You talked about guardianship, talked about things like pensions, etc. So what I would suggest is that take the advantage of asking your questions while we have. So this is how to balance Sharia inheritance rules with UK inheritance tax. I mean, that's what this solution tries to do, doesn't it, Rizwan? But
yeah, and in terms of the Sharia side, we worked with someone, Mufti Faraz. I'm sure Simply Ethical's well aware of Mufti Faraz and his expertise in this area, as well as in the investment side and the Sharia compliance side. So Mufti Faraz has had a look at our wills. We've discussed them in detail with him, and we've discussed them with other scholars as well. And and from his perspective, he's signed off on from the Sharia compliance side in terms of the wills themselves. So the solutions we believe are Islamically compliant, as well as saving from the inheritance tax. So in terms of the balance, I would say it's not necessary to worry too much about balancing it. It's more a case of making sure that you have the solution in place to make sure that you don't pay inheritance tax unnecessarily, because no one wants to pay tax when they don't need to pay tax. And I firmly believe that Muslims take proper advice on this, whether it's from ourselves or others. There doesn't need to be unnecessary inheritance tax paid. That doesn't mean that the inheritance tax won't eventually be paid, as in this solution. The tax bill is still potentially looming on second death. There may still be tax on second death. It all depends on how much is left within the trust fund, how much has been distributed out, who's received the assets, and whether it's kept within the trust fund or not. But again, there's other avenues we could look into in terms of creating lifetime trusts and passing assets to there. So from an inheritance tax perspective and balancing with the Sharia side, I would say that it can certainly be done, and that's what we're doing. That's what we've been doing over the last 10, 15 years, inshallah.
Okay, how are this seminar has been so enlightening. Thank you. Can you please advise what would happen to the inheritance if one doesn't have an Islamic will implemented?
Okay, yeah, so that goes, I guess, back to the point I made about intestacy. When someone doesn't have an Islamic will, or let's say, well, let's take a scenario where they don't have any will, then it's according to the intestacy rules. It'd be up to the surviving family to come together, and if they wanted the distribution to accord with the Islamic distribution, they would all have to come to some agreement, and we can prepare something known as a deed of variation in that scenario, which would then allow for the Islamic inheritance to be implemented. Now, that's not an ideal solution. The much better solution is to have a will in place in the first place. But it's not ideal because oftentimes there will be young beneficiaries. They can't act to reduce their share. You can't act on their behalf to reduce their share. Quite often there will be disputes between family members if you try to reduce one person's share just by virtue of it being the Islamic shares. Some will say, I had a discussion with a potential client this morning who was saying, my dad did a will. The will was written by himself. He said, I just want my son to get the house, and my other son's looking after our property in Pakistan. The will was badly drafted, and now the daughter who wants to deal with things Islamically, who's spoken to her siblings and they're not taking any of this on board, she's basically stuck because she can't do anything. She can't get her share. She can't deal with things. She can't do what she feels is best for her father in terms of the Islamic inheritance. So it's not an ideal solution, but it can be done if all of the beneficiaries are adults and come together, which is not always the case.
How long do you have to write a will, and who has to be present?
In terms of writing a will, it can be done within a few hours, or as some people take months or years. It really depends on the individual themselves. Now, obviously, I wouldn't recommend doing it within a few hours because that means that you're probably heading off somewhere tomorrow. The best thing is to do it when you have some time, And usually 9 times out of 10, it can be done within a couple of weeks, no more than a month or 6 weeks. So there's no real issue with doing it quite quickly, as long as things are done correctly and you take the proper advice. My suggestion is always to get these things sorted whilst you have time. Oftentimes, though, it's a case of mom or dad's ill in hospital, and the son or daughter calls and says, mom wants to do her will or dad wants to do her will, can you help? In those scenarios, it really depends on what capacity parents have, what capacity the individual has, and whether we can complete those wills. In terms of who has to be present, well, the testator, the one who's writing their will, has to be present, and up to two witnesses. So that's usually ourselves or whoever's witnessing the will. They would have to sign alongside the testator.
Okay, if the deceased has income and assets from other countries outside of the UK, will this be taxed in that country or with the UK rules?
Okay, yeah, that's a good question. So it depends on something called domicile. So domicile is what you would say is the permanent residence or the permanent home of the individual. So you could live in the UK, but you've moved from abroad and you've planned to work in the UK for 10 years, but then moved back to your home country. So in that scenario, you wouldn't be domiciled in the UK, you'd be domiciled from your home country. And there's quite complicated rules on this, but if you've lived in the UK from 15 out of the last 20 years, then you're automatically deemed to be domiciled in the UK. So that will be the way you are domiciled, unless you could prove otherwise via some other evidence that you're not actually UK domicile, which is quite difficult to prove. So when you're UK domicile, you basically pay inheritance tax on your worldwide assets. So if you've got assets in the UK and abroad, you would pay inheritance tax on your worldwide assets. You could potentially get a inheritance tax rebate if you've already paid inheritance tax on assets abroad, but that will depend on which country you've paid it in and if there's a tax treaty between the UK and that country. So it gets quite complicated from that side. If you're not UK domiciled, for example, you've just moved to the UK, you're doing your will, or you live abroad and you come to the UK sometimes, you've got property in the UK, then you will only be taxed on your UK immovable assets, so property in the UK. So that will be what's taxable.
Okay. The letter of wishes has no legal standing. Who are the beneficiaries of the trust fund?
Sure. Yeah, so the trust fund has, the will itself, it creates a trust fund. It appoints executors and trustees of the trust fund, and it lists beneficiaries of the trust fund. Yeah. The way we structure our wills, we have two main types of will trust. We have what's known as a life interest trust will trust, and we have a discretionary trust type wills. With the flexible life interest trust wills, one of the beneficiaries or one or more of the beneficiaries is entitled to the income, but the capital can be paid out to whoever the trustees choose. With the discretionary trust, the capital and the income is at the discretion of the trustees. Now, sometimes clients come to me and say, well, hold on, whose discretion are we talking about? And the discretion is the trustees, but they're limited in how they can exercise their discretion. So they can only exercise their discretion in favor of the beneficiaries. And the beneficiaries are the ones named within the will itself. And the point of giving them that discretion is, the two main points is from the tax efficiency point of view, and from asset protection. So I didn't come on to asset protection in great detail during my presentation, but one of the reasons why you would potentially give a share to protect assets via trust fund is if you've got young beneficiaries, they're immature, or they're on benefits, or they're going through financial issues, or they're going through marital issues. If you have any of those scenarios, you don't necessarily want to give the assets outright to the beneficiaries, because if they're still young, as soon as they hit the age of 18, they can take their money and buy a fast car, waste the money, do what they like with the money. If they're immature or there's some other issue there, you don't want to give them the money. It's potentially again going to be wasted. Similar with divorce, this divorcing partner could potentially take at least half the assets, and if there are financial issues, you don't want to just give them a check for it to be lost the next day. So the trust fund enables the trustees to safeguard the assets for the beneficiaries. Now, there is a point there which says, well, why give the discretion over to them? What if they change their mind and give all the money to one of the beneficiaries, or give it to themselves if they're one of the beneficiaries? And this is where the importance of choosing the right trustees comes into play. Firstly, we always recommend at least 3 trustees, so it's not always going to be on one person. Secondly, you can incorporate certain rules so that there has to be a majority or unanimity from the trustees. So if you got one bad egg as a trustee, that's one thing, but finding 3 bad eggs, I would say that you've really chosen the wrong people on that side. From an Islamic perspective, again, the people who you choose should be aware and take due consideration of the Islamic side. So the verse in inheritance actually mentioned this: anyone who takes away the wealth of an orphan, eats up the wealth of an orphan, then they're eating up a fire into their belly, and they will soon be blazing the enduring fire. Yeah. So as a person who's making your will, you can only do what you can do. When you pass away, ultimately it's up to those who are left behind to deal with things. Even if you had a simple scenario where you had a simple Islamic will, someone is going to be in charge of the assets, especially if you have young beneficiaries. So there's something called, there would be on bare trust for those beneficiaries. Now, they could misappropriate those assets, they could do something wrong with those assets, and ultimately legal action would have to be taken against them for you to recover it. So whatever the scenario, ultimately it's the trustees who you've left behind who are going to be responsible for dealing with things. So the fact that as the questioner said, the letter of wishes doesn't have a legal effect, in one sense it does, because if this does go to court and if there is a dispute between the trustees as to what should happen, then the judge will take into account the letter of wishes, in the sense that he will look at that and see if that was reasonable in the circumstances and to deal with that. So the structure that we work with quite often in terms of the trust, we believe is the best structure for many clients. It's not always the best structure. Sometimes a simple scenario can do the job, but taking into all of the different factors, inheritance tax, protecting assets, making sure your wishes are adhered to, etc., then often the trust is the best method.
Right. Will the issue of gold and other types of jewelry, will this have to go in the will, or will it can simply just be gifted before death?
So in terms of gold and jewelry, this does go into the will. It's part of the estate, just as with any of the other assets. It can't just be gifted away on death, because if the person is anticipating that they're going to pass away, it goes back to the point I made earlier. The individual has to make sure that they don't unnecessarily or incorrectly give all the assets to one beneficiary over the others. But they could potentially gift during their lifetime, so they can gift assets of gold or jewelry to daughters or whoever they may feel is entitled to it. Alternatively, within their will, within the letter of wishes, for example, what they could do is say that I'd like my daughter's share, as an example, quite often is the case. I'd like my daughter's share to be made up partly of the gold jewelry that I have. So in that case, it's known as a wasiyyah, and as long as the share is within the share of the beneficiary who's entitled to it, then that can be done, inshallah.
Okay, great. Right, by placing all the estate into a trust fund, is that in line with Sharia? Should the 1/3 rule not apply?
I'm not sure what you mean about should the 1/3 rule not apply. We're not, with the will trust, what we're not doing is making a wish for the whole estate. what we're doing is passing the assets into the trust fund. We then have a separate letter of wishes, and the maximum that the letter of wishes states is applicable to give to other beneficiaries is the 1/3. So from an Islamic perspective, we're still adhering to the Islamic rules of inheritance. The letter of wishes sets out exactly who should get what in terms of the Islamic inheritance: parents, spouse, children. But within the letter of wishes, we also mention about the 1/3. Maybe it's 1%, maybe it's 5%, maybe it's the full 1/3 that the individual wants to give. But the will trust isn't in opposition to that. The will trust is just the means by which we make sure that that happens.
Okay, fantastic. At the point of death, the legal owners automatically become owners of the estate of this deceased. From a Sharia perspective, the trustees do not have the discretion to determine who gets what, when.
Okay, yeah, so this goes back to the other point I was discussing earlier. There is that view, and it's a view that's held by some as to the fact that we cannot have any discretion in any of this matter. The shares in the Surah An-Nisa are clear. The wife gets an 1/8, the parents get a 1/6 each, the sons and daughters share 2/3, 2-to-1 between the remainder. Now, if that's an individual's view, then we can prepare an Islamic will which is in accordance with that. My point to the questioner would be that quite often that will mean a tax bill of £200,000, as in that example. From an Islamic perspective, and this is something that we have, like I said, discussed with scholars on this point, and not everyone is in agreement with this, but I believe the majority of scholars that we are. The point being that inheritance tax is something which can be avoided in this scenario. And it's not a case of getting around the Sharia, it's just in our legal jurisdiction that we're working within, we can ensure that both aspects are confirmed, both that the inheritance goes to the right Sharia beneficiaries and that the inheritance tax is not payable. So in that scenario, I would say most individuals would be happy to give, from a legal perspective, the discretion over to the trustees, with an Islamic understanding that they have responsibilities, and the responsibilities are set out in the letter of wishes. So for some, I would say if you're not happy with that, then the simple Islamic will is an option for you, but it will cause a number of issues for a number of individuals with inheritance tax, with protecting assets, with their wishes and making sure those wishes are correctly adhered to. So it's one of those points that I believe that the discretion is allowed in this scenario, and that's what we've taken our advice from the Islamic perspective on that side.
Yeah, great, Rizwan. Thank you very much. I believe that's pretty much all the questions. So I think, just on that last point, I think my personal opinion, and this is my opinion, and I'm not a scholar, but it's about being smart, but at the same time being faithful and sincere to the Sharia. And I think if you've got everything lined up, for example, the trustees that you appoint, etc., they all have that understanding that, look, your intention is to make sure you want to do everything in line with the Sharia. The letter of wishes is very clear about how you want the estate to be distributed, and that's in line with the Sharia. Then there shouldn't be any issues at all. You're just being smart about not having to pay the inheritance tax. So yeah.
And on that point, I would say that there's the fundamental principle within Islam that deeds are by intentions. Now, if your intention via this will is to subvert the Islamic inheritance, then that is a completely different matter. But my experience with my clients and my experience with dealing with this is it's not that inheritance. That's not the intention. The intention is genuinely to make sure that your inheritors are properly cared for, that they get as much as they can in terms of the inheritance, and it's done in the best manner possible given the scenario we're living in. So I think it's sometimes easy to just say, well, there's no discretion, that's the end of it. But my research into this and looking into it with scholars and with individuals and practically over the last 10-15 years leads me to believe that this is the best way to deal with it. Not always. Sometimes it's better to have it set, fixed, because you know that there will be issues within the family if you don't do that. But in those cases, that's what we advise then. So it really depends on the case-by-case scenario. But most people, in most cases, this is a good solution and works well.
Yeah, and I think that one overriding experience I've had is, you know, often when people look at the Sharia rules on inheritance, and this is a bone of a contention sometimes for people, that they're very easy to point out, oh, you know, the males get twice what the females get, or whatever. And even my experience with Muslim clients is that they are sometimes uneasy about the rules they're facing on inheritance, because they somehow feel that it's not just in their situation or right. I think it's one where, you know, what Rizwan sort of said is that, look, God has laid out these rules for us. He's the giver of that wealth to us. We're owners while we're alive, and then we leave it to be passed on when we move on from this earth. So we've sort of taken a trust of that wealth, and then we're hopefully discharging that trust when we're leaving this earth. And I suppose, you know, may Allah make it easy for all of us to sort of have the understanding that if God has ordained something for us, and He's got a formula in place, then He surely knows best. But it's sometimes extremely hard in situations for people where there have been instances where, for example, one child has done so much more for the family than other children, or there's been difficult relationships in the family, or other scenarios which are too many to go into. But, you know, it's sometimes just good to ponder on that, and, you know, take good advice from people like Rizwan and Haroon, who do this day in, day out, and advise people, and hopefully can reconcile these different scenarios. But it can be difficult. But look, I'd like to thank everyone that's attended. Thank Rizwan in particular for a great presentation. This is something which I'm sure those who didn't see it live will be able to view and get benefit from, and many, many more people will be able to do that. So I hope everyone found it basically. Now, just two things quickly. If you are basically want to get notifications of other seminars, we've got Mufti Faraz doing a regular monthly seminar for us. We've got other very interesting topics coming up. Please do subscribe to our YouTube channel so that we can keep you up to breast and up to speed with what's going on. And just like to say thank you again for your attendance. Thank you, Rizwan, again for a great presentation. And we look forward to seeing you guys in future presentations. Thank you.
Thank you.
Assalamu alaikum.